And we are recording. Yeah. All right. We are recording and live at the Ad Hoc Commission on the Discipline System Moral Turpitude Working Group. I will take the roll. Melanie Lawrence.
Here.
Ellen Pansky. Don't see her yet. And Sean Seleg.
Here.
Okay. At this time, we are going to shortly take a break to wait for another member of the working group to join. But if there's anyone from the public that would like to make public comment now, they can do so by raising their hand. And I don't see anyone with a hand raised at this time. So we will also call for public comment when we resume. We're going to take a short break in this meeting and resume this meeting at 3:30 Pacific time. So until then, we will be on break. Hi, Ellen. I wasn't sure when you were going to be able to join. So I brought everybody in, we took public comment, there wasn't any public comment, and then we adjourned until 3:30. I can try and get everybody back together if that works. You're on mute, Ellen, so I can't hear you.
You think I would learn? I jumped straight in the second I got out, so actually I would be just fine coming back at 3:30.
Okay, then
Thank
we'll
you.
resume
Thank you,
at 3:30.
Thank you.
Okay. All right, we are recording again, and I will note that Ellen Pansky has joined us. I said at the beginning that I would ask for public comment one more time. So if there is anybody in the public that wishes to make comment, if you would please now raise your hand. And I don't see anybody in the public raising their hand. So we will move on to the agenda for today. The first part of the agenda today, Chris Jagard, I apologize if I mispronounced your last name, Chris, will provide us an overview of the C cases to kick off the discussion. So I will turn it over to, and I don't know if Chris or George, who's going to start this.
Right, well, why don't I, can you hear me, Justin?
Yes.
Okay, terrific. Why don't I share my screen since I'm going to present the majority of the slides, and then I'll just,
Okay.
Chris can just talk.
Thanks,
Okay,
Lisa.
right. Okay, let me share my screen. Okay, can you see my screen, the PowerPoint?
Yes.
Yes, now we can.
Okay. Okay, so this is going to, okay, so the purpose of this presentation is to share an analysis that the Office of Research and Institutional Accountability conducted on criminal conviction cases that reached disposition in state bar court. But before we share that analysis, we're going to turn it over to Chris Jagard of OCTC, who's going to give us a primer on C cases that go to state that OCTC receives and the process, etc. Take it away, Chris.
Thank you, Lisa. Oh, great. So you moved the slide. Thank you. So this is the first slide. So I'm Chris Jagard. I'm one of the Assistant Chief Trial Counsels, and I manage the Conviction Monitoring Unit up in San Francisco for the most part, although we have attorneys in the Los Angeles office as well. So I'm just going to give a brief overview, just a little bit of background before we get into the numbers on the C cases and Corey versus non-Corey cases, and I'll explain that in a minute. The first part is just kind of to highlight how we receive reports of criminal convictions. And so I'm just going to go through each column briefly. Prosecutor report, and this is B&P, the Business and Professions Code 6101B. So these are all specified by different parts of the statute. Prosecutors, district attorney's office, city attorney, whoever's prosecuting the case are supposed to report to us when they file criminal charges, that's felony or misdemeanor charges. And as soon as they learn that the defendant is an attorney in that particular case, and this is one way that triggers our monitoring of conviction cases that are not final. So these are when charges are filed. We would then monitor that case. The third bullet point down triggers monitoring pending receipt of the certified copy of record of conviction. So that means we're going to monitor the case until conclusion. In other words, the case is either dismissed or it proceeds through trial and conviction, and we get a certified copy of that record of conviction from the court. And the court report is on the other side. I'll get to that in a minute. It's one of the other columns. The second column is an attorney report. And so attorneys are responsible for self-reporting certain types of convictions. When they're charged with a felony, they're required to report that to the state bar. And then they're also required to report the second bullet point down, convictions of felonies or certain types of misdemeanors that may involve moral turpitude. That also would then trigger our monitoring of that particular case until, like I said, charges are dismissed or there's a certified copy of the record of the conviction, whether it be felony or misdemeanor. The third column is criminal offender record information. We call that CORI for short, so CORI. That's what CORI stands for, criminal offender record information. And this is obviously the re-fingerprinting triggered in 2019, triggered many of the referrals from Mariah to OCTC. We receive this information from the DOJ, or I should say that Mariah receives it and transmits that information to OCTC once we have a record of conviction. So again, it would trigger our office's monitoring of the case pending finality. In other words, assuming all appellate rights have been exhausted for that particular conviction. And then the last column is court reports. So the clerk of the court is required to send us certified copies of the record of conviction. That frequently doesn't happen. So our paralegal staff in the office has to usually request the record of conviction from the various courts. But those are the various ways in which we receive reports of pending felony or misdemeanor matters in criminal court. We also obtain information on our own through media, other sources. Other people report them to us at times. And so we learn about the convictions in various, or the charges filed in various different ways, in addition to what you see on this page. Lisa, if you go to the next slide. So on this slide, on the right-hand column, you'll see a sample of our transmittal form. And then on the left, this is the conviction transmittals that we file, OCTC files in state bar court. Again, Business and Profession Code 6101. Within 30 days of receipt of the record of conviction for any conviction which involves or may involve moral turpitude, OCTC shall transmit the record of conviction. Sometimes we transmit other information with that record of conviction to establish the conviction itself, such as the plea agreement. Sometimes there's transcripts from the court hearing, etc. We transmit, and then the bottom part of this slide, whether or not the conviction is final, and then Rule 5.341. What that means is we transmit with or without finality, depending on the status of the criminal case. So if we're transmitting without finality, that would mean there's a conviction at the superior court level, for example, but the appellate rights have not been exhausted for the respondent. So the respondent may be appealing that case in the California Court of Appeals, Supreme Court, for example, and so the conviction is not final. But in that particular case, we would transmit it without finality. If there is finality, obviously we check the other box. You'll see on the right-hand column down there under A, I believe it's A, C, evidence of finality of the conviction, which we transmit. Okay, next slide, Lisa. This next slide refers to the interim suspension rule. So court shall suspend an attorney if the crime of conviction is a felony. It's the most common. If we receive a felony conviction, and this is not charges filed, this is where there has been a conviction. It may not be final, the attorney may be appealing it, but regardless, we can still file the transmittal without finality, and the court would place the attorney on interim suspension in that situation. There is a provision where the court can decline to impose interim suspension in the interest of justice, et cetera. And the rule is cited there, Business and Professions Code 6102A. Okay, Lisa, next. And then once this is the background on the actual discipline, once there's a final conviction and the appellate rights have been exhausted, for felonies, there's a summary disbarment procedure under 6102C. That's for cases involving moral turpitude as a matter of law. That's usually theft, fraud, as it's stated in the bullet point 1 there. And then there's also facts and circumstances. So if it's not per se a crime, the state bar court can send it to the hearing department and request a hearing to determine if moral turpitude is involved. If it is, the attorney will be summarily disbarred. Let's see, the misdemeanor convictions, as I noted in I think it was the first slide or second slide, those are sent to the hearing department for a hearing on the facts and circumstances to determine whether the crime involved moral turpitude or other facts and circumstances warranting discipline. Okay, next slide.
I think that's it.
Okay, I think that's the end of the intro, but I'm going to be available to answer questions throughout. If there's any questions about the Corey cases, non-Corey cases, whatever else might come up. So thank you, Lisa.
Okay, sure. Okay, thank you, Chris. Okay, so now I'm going to turn to the analysis that staff and Araya conducted on this very topic. Before I get started, I'd like to acknowledge the work of Kevin Thompson, who's a new analyst in Araya. One of the best parts of my job is I get to find great people to add to this team, and this was a big assignment for Kevin, and he passed with flying colors. So congratulations, Kevin, on this really illuminating analysis. He did this work under the direction of Ron B. So the analysis of explores criminal conviction cases that reached disposition in state bar court between this time period here, March 3rd, 2019 to February 28th of 2022. We tried to align this time period as much as possible with the analysis that we did on original matter cases that reached disposition in state bar court that we did for this working group earlier in the process. So the purpose of this analysis was to explore case characteristics and outcomes among this set of cases, particularly the non-disciplinary outcomes. And then throughout, we made it a point to compare Corey cases versus non-Corey cases. So the way non-Corey cases are basically, if you remember those 4 types of cases that C cases that come into the state bar, Corey cases was one of them. So the non-Corey cases were the 3 other ones where who was the source of the reporting. And so the approach we took was, again, we identified 307 C cases that reached disposition during that time period. We drew the case characteristics based on this actual charging document. So this information, what we extracted from this charging document were information like, what was the underlying criminal conviction charge, felony versus misdemeanor, whether or not the transmittal was per se versus facts and circumstances. And as we go through analysis, facts and circumstances, we're using the term hearing required. So when you see that label in the analysis, that's what it refers to, facts and circumstances. And then we also, like I mentioned, always explore whether or not the origin of that referral. So it's either going to be Corey versus non-Corey. So here are the case disposition types. So we analyzed whether or not the case made a state bar court. So what happened? We either looked at whether something was a non-disciplinary action, and we'll describe what that is as we do the analysis, or it resulted in discipline, which is private removal, public removal, probation, suspension, or disbarment. So the non-disciplinary action is just a big bucket of it's not dismissals in the true sense, and we'll describe what that means as we go through. And then finally, we looked at method of case disposition. So a case was either disposed via pretrial, trial, stipulation, or default. Let's get started. So let's talk about these C cases, what they are, and how they were transmitted. So first, really big picture, the analysis showed that during this time period, 61% of the cases that were disposed in state bar court originated from Corey. We also learned that the majority of C cases were based on misdemeanor convictions. However, this varied by whether they were a Corey case versus not. So the non-Corey cases were more likely to be based on felonies than Corey cases, and then the opposite was true for Corey cases. They were more likely to be based on misdemeanors versus felonies. So that has to do with the underlying conviction charge. Next, we found that the majority of the C cases that were transmitted, they were transmitted with a hearing required. That's here on the left, that's all cases, but when you disaggregate it by Corey versus not Corey, you see a difference. And that is that Corey cases were more likely to be transmitted with a hearing required than non-Corey cases. In contrast, the non-Corey cases were more likely to be transmitted with per se. And here we explored the length of time since conviction and compared that with transmittal. So starting over here on the far left with all cases, we found that the majority of C cases had a conviction within the first 4 years of that conviction date. However, this really varied by whether it was a Corey case or not. So going all the way to the right, the non-Corey cases, the vast majority of them were transmitted within 4 years of the conviction. But in contrast, for Corey, the bulk of the cases, the majority of them, a slight majority, 56% of the cases, were transmitted with between 5 to 10 years of a conviction. Justin, I see George's hand raised. Do you want to call on him now, or do you want to wait until the end?
Sure. I mean, George, if you have.
Yeah, I just wanted to ask, does this time frame, and maybe Chris knows the answer to this, does this time frame encompass the time frame of the cases that were looked at? Does that encompass the time frame when we got the backlog of fingerprinted cases because of the re-fingerprinting process?
Yes, George, you're asking whether this the group of cases that we're looking at right here encompass that? Yes, they would, because it's 2019 to present. So this would encompass the time when we received, I think we received the initial batch in 2019.
Okay, thanks.
Can I ask another foundational question? I'm still unclear where these non-Corey cases are coming from. I mean, it looks like I'm bad at doing statistics, but what, maybe 40% of these cases, 45, I don't know, are coming from sources other than the fingerprinting, which surprises me. And I'm not clear at all where all these other cases are coming from.
Those would be through the prosecutor's report or through us just finding out on our own through media, newspapers, articles, or court reporting it, other people reporting it to us. We open a case for monitoring. But frequently it's either self-reporting by the attorney or the prosecutor sending us a referral. Those would be the non-Corey cases that you're seeing here.
Do you have any breakdown between those categories in the non-Corey group?
A breakdown in terms of what?
Like how many are self-reported? How many come from prosecutors of the non-Corey cases?
Lisa would have to answer that one. I'm not sure. I don't think so, but.
After this, no.
Not here, but I think we report that in the ADR, don't we?
I think so too.
Mm-hmm.
Okay, any other questions? Okay, continue on. Okay, so that has to do with length of time since conviction. We did a similar analysis that we looked at the actual offense date, and it's pretty much the same pattern. So I'm not going to go through this again. I distributed this PowerPoint on Friday for the working group members. So it's the same pattern, but like I said, in the interest of being thorough, we added this additional analysis. Okay, so now we're going to look at the outcomes of these cases. We're going to look at disposition method, what happened to them, what was the outcome, and then do a deep dive into disposition outcomes by the manner by which it was transmitted, and then look at the non-disciplinary outcomes. So let's look at disposition method. So take a look on the right, starting with all cases, 17% were disposed by trial, 42% were disposed by pre-trial, 37% stipulation, and 4% disposition. Non-Corey cases were more likely to be disposed by trial compared to Corey cases. That's 36%. That's this right here, 36% versus that 46%. And Corey cases were more likely to be disposed by stipulation. That's at 52% compared to 15%. So this has to do, again, like with how the cases were disposed once they reached the state bar court, and there's the variation by Corey versus non-Corey. And this gets a little bit deeper into what the exact discipline was, if there was discipline versus whether or not. So the red bar represents non-disciplinary action. So let's start here on the right. 38% of all cases were disposed with non-disciplinary action. And this varies whether it was a Corey case versus a non-Corey case. 53% of Corey cases were disposed with non-disciplinary action compared with Corey cases. So I'm just, in the interest of time, I'm just going to continue on. I know that the biggest interest in this group was to understand non-disciplinary among case cuts. So that's why I'm focusing on these red bars right here. So overall, 38%, it varies by whether it was Corey or non-Corey. This looks at whether or not that there's a variation in outcome versus method of transmittal. Again, here's our 38% on the left for all cases. And as you can see, it does vary whether or not that OCTC transmitted it with a hearing required versus per se. 40% of cases that were transmitted with hearing required resulted in non-disciplinary action compared with 15% of cases that were transmitted per se. And as you can see, these, just quickly look at the bars of the cross, go all the way to something like disbarment. There you see that variation. There are only 9% of the Corey cases were disposed with disbarment compared with 27% of the cases that were transmitted with a per se request.
Lisa,
Okay, now
Lisa,
sure.
could you go back to this? Yeah, thank you. So for our disciplinary experts, I'm curious. I'm surprised that 15% of the per se cases result in no disciplinary action. Why is that? Why would that be? I would think these would be 100% disciplinary results.
I'm sorry, there was someone else, George? Oh, no, so I guess, I think it's because some of these, perhaps these people were disbarred in other matters, or so in other words, if they're already disbarred, we would close the C case, right? Occasionally something happens and the conviction is overturned, for example, after we thought it was final, for example, and it was transmitted. I'm not sure exactly without seeing each case, but there's usually an explanation like that where the attorney may have been disbarred in another matter.
I see. Okay, thank you.
Okay, so now we're going to look a little bit more closely into the cases that were dismissed with non-disciplinary action to understand them a little bit more deeply. So there was 117 of them, and what this shows is that the vast majority of them, 98%, were disposed in pretrial. In other words, they didn't go to trial; they were disposed in pretrial. And and if you go all the way to the 18 cases that were non-Corey, 100% of them were disposed in pretrial, and in the case of Corey, the same thing, because the majority of them were Corey cases, again, just disposed in pretrial. Does anyone have any questions about this for Chris on what we mean by trial versus pretrial? Great. Okay, so now again, a little bit deeper dive into these non-disciplinary actions. Here's the total 117 disaggregated, whether it was disposed by pretrial versus disposed by trial. These are two columns. And here's our 115 that were disposed in pretrial. The biggest category is that it was dismissed by OCTC on merits. The next biggest category is that it was disposed with a warning letter to the respondent. And the next biggest category was an ALD, the agreement in lieu of discipline. In contrast, for the two cases that were disposed in trial, it was dismissed by the State Bar Court on merits. Okay, and then finally, we're going to look okay, so now I'm going to go through a series of slides that show the non-disciplinary action rates, and we're going to see whether it varies by these different groups, taking into account multiple categories at once. So what this looks, the way you interpret this slide is like this. So on the left are a set of bars that these are all the Corey cases, and the way you interpret it is like this. Here on the left, 32% of Corey cases that were transmitted within 1 to 4 years of conviction resulted in a non-disciplinary action. The older the Corey case was, the higher the rate of disposal by non-disciplinary. So all the way to our red bars here, 70% of Corey cases that were 11 years or older closed or were disposed with no disciplinary action. In contrast, with non-Corey, it was 33%. But ultimately, what you should take from this is that as the case gets older, the dismissal rate increases. So whether it's a Corey case versus a non-Corey case, the length of time of conviction really matters here. It's a positive relationship, whether it's Corey or non-Corey. But for Corey, the non-disciplinary action rates were higher than non-Corey. Okay. Does anybody have any questions about this and how to interpret these slides? This particular slide. So this is an analysis that looks at time since conviction. I'm just going to skip this because this is a type of conviction. It's ultimately this. So here we're looking at, we disaggregate by whether it's a case that originated as a result of a felony versus a misdemeanor. Over here on the left, so for whether it was a felony or misdemeanor, the older the case, especially for misdemeanor, the older the case, the more likely it was going to result in a non-disciplinary action. Whereas felony, there were so few of them. There were fewer of them, but ultimately still 0%. If there was within 0 to 4 years, I mean that means like there was no cases resulted in non-disciplinary. All the way over to the red bar is 20% if there was 11 years or older. Okay. So that has to do with whether it was the type of conviction. And this is basically the same thing. See, before we looked at time since conviction, this is time since offense, and it's the same pattern, essentially. We just have this here for purpose of being thorough. So again, a positive correlation. Okay, and then time since offense. I don't know what this is. This might be, oh, this is time since offense for a type of conviction. So yeah, so we looked at it time since conviction, time since offense versus whether it's a felony or misdemeanor versus Corey versus non-Corey. So the same type of analysis, just looking at the time, looking at time differently. Time conviction versus time versus offense is the same pattern. Okay. All right. Does anyone have any questions about this? Because I'm about to do a little wrap up now. No. Okay. Okay. So here's our summary, our findings. This again, the majority of cases that we transmitted to State Bar Court during the time period analyzed were Corey cases. The majority of them were based on misdemeanor convictions. The majority of the cases required a hearing, and more than half of them transmitted during this time period were transmitted within 4 years. But 10% were transmitted with 10 or more years since time of conviction, and that pattern holds whether you're looking at offense date. And then down here, 91% of non-Corey cases were transmitted within 4 years. And that varies by whether it's Corey cases versus not. If you look at outcomes, we see that 42% of all C cases analyzed were disposed during pre-trial. 38% of all C cases were disposed with non-disciplinary action, and that varies by whether it was Corey or not. Cases transmitted with a hearing were more likely to result in non-disciplinary action, and the length of time is really important here. Back to the last two slides, some of the last bullet points have to do with examining discipline rate, non-disciplinary action rates for Corey versus non. So 70% of Corey cases that were more than 10 years old were disposed with non-disciplinary action. And if you look at whether or not the underlying charge was misdemeanor or felony, 76% of cases that were based on convictions and they were older were dismissed with non-disciplinary action. It's a lot to take in, but ultimately, like I said, the patterns we see, no matter what we analyze, there's much variation between Corey versus non-Corey, length of conviction, whether it was misdemeanor or felony. There's all these factors that are going into play that are showing this variation in a non-disciplinary action. Okay, does anyone have any questions?
Yes, that last statistic about resolution of cases either pre-trial or by stipulation, I'm not really understanding what fits into the category of pre-trial. Those aren't all OCTC dismissals, are they?
I'm gonna let Chris describe, share how to describe these cases that are disposed in pre-trial versus trial in these different categories.
Right. So these cases that we're looking at here in this slideshow are all cases that have been transmitted to State Bar Court. So we're not looking at cases that we're monitoring or that haven't been transmitted, right? That's not part of this study or this slide presentation. So everything you're seeing here has been transmitted. So when you see dismissed on merits OCTC, that refers to cases where OCTC has filed a motion requesting dismissal, usually in the interest of justice under that subsection, and the court has dismissed the case based on OCTC's motion.
No, I'm sorry, Chris, I understand that. What I'm saying is there were two slides, and in particular, the very last slide, where there's a breakout between, I think it's the very last slide.
Well, those are bullet points, but I would like to take us to which one, and I'll take us to the figure afterwards. Which one, Ellen, here?
What I'm asking is, if you look at the first bullet point, it says 42% of all C cases were disposed pre-trial, 37% disposed by stipulation. I'm assuming there's some overlap, or I'm not following how you got to that statistic, because most of the stipulations are, if not all of them, going to be pre-trial, or unless you're distinguishing between partial stipulations as to facts only. So that statistic, I'm just not following the distinction between resolution of cases pre-trial as opposed to, or dismissal, I should say, as opposed to dismissal via stipulation? I'm just trying to understand the difference between those two categories.
Okay, Krista George, you want to explain the distinguish the spectrum between these two?
At least I'm not sure. I'm not sure exactly what that 42%, because unless it includes the our voluntary dismissals by OCTC, the 42%, right? That must include that, right? 42%, that must be reflected there. But I'm not sure, Lisa, because it seems like everything else, 37% stipulation. So in other words, the cases that were dismissed there were no stipulations there, right? So that wouldn't be, the stipulation category would be separate. But I think Ellen is correct that the stipulation is generally pre-trial, so.
I mean, the reason I'm asking is, it looks like a full 79% are resolved before trial. That much seems clear, right?
Yes.
Okay.
Any other questions from anyone?
Okay, so I think I'm going to bring it back around to the charge of this working group was to kind of examine the moral turpitude process. And we did that initially by doing the research on the original cases and their transmittal and whether or not moral turpitude was dismissed any more or less than any other allegation. And that showed that it wasn't statistically different. And so we reviewed some of the cases. I know we sent some cases to Ellen, and Ellen provided us with some cases, and those cases were C cases. And so that's why we've done the process today, is look at C cases and whether or not they're dismissed any more or less, because I know that the issue is once those C cases are transmitted to state bar court, they become public, and that sets a whole other thing in motion. And I know that that is where your concern has been, Ellen. But to bring it back to the high level, now that we've reviewed lots of statistics, we reviewed the dismissal of moral turpitude charges, I'm kind of trying to check into the working group as, are there recommendations that could possibly come out of this other than, I think there is a strong correlation with what the ENEC working group is doing about providing a ENEC in C cases. So there's an opportunity for the respondent to present things before it becomes public, before it goes over to state bar court, and providing that additional information. But I would really like to understand from the working group members, are there recommendations or things that this working group thinks should be brought to the full commission?
I don't have anything.
I have several things.
Okay.
So I appreciate, all this work, but the question in my mind, and I think that Lisa is still working on it, or your people are still working on it, there seems to be a disconnect between the list that I provided back in February and these statistics. And I first provided, well, just to go back for a moment, as I'm sure you all appreciate, the respondents who had cases dismissed are reluctant to have their identity disclosed publicly, since, if they went through a state bar procedure or proceeding and they, were exonerated in essence, they don't want to have to reveal their names publicly. And so I initially provided a list to Lisa and to Justin that identified the cases very generally. Then I believe I went back and I identified them by state bar case number. I don't think that the state bar had success working with that. So then I provided a list with more identifying information. But the two reports that we've gotten from staff, the initial report that analyzed the number of cases with dismissed moral turpitude counts, and then this most recent PowerPoint presentation don't have any identifying information about the respondents. So there's no way, for me anyway, to compare apples to apples to see why there seems to be a pretty significant distinction between the cases that I was able to gather. And keep in mind, I could only provide either cases that my office worked on, that other respondents counsel provided to me. And there's a lot of respondents counsel now. Some are active in ADDC and a lot aren't, or those that resulted in review department decisions that we were able to pull up. So I don't even know if the cases, the list that I provided is the full list of cases in which moral turpitude counts were dismissed and or the entire case was dismissed, because there's no way for me to gather that information. But in addition to that, I don't know whether the cases that I provided are the same, or what subset of them are the same as the cases that form the basis of the presentations we've got from the state bar. I provided a total list of 18 cases, and I can't be certain, but I'm fairly positive that these cases are in the same time frame as the ones that are in the PowerPoint that we just looked at. Maybe there's one or two outliers, but I think they're basically the same, very similar time frame. And I don't know if there needs to be a reconciliation of the statistics. So I don't feel that the information that we have so far has yet been analyzed definitively, and I'm not sure. I would like to try to understand why there seems to be a fairly significant difference between those cases which I was able to gather, admittedly anecdotally, from the cases that form the basis of the state bar staff analysis. But the other thing is, looking at this most recent analysis, it does seem without question that the vast majority of these C cases are resolved cooperatively. And it seems that there are a significant percentage of them that are resolved without public discipline, if not by straight out dismissal, by admonition or referral to ADP, which is the Alternative Discipline Program for people who have demonstrated mental health or substance abuse problems. And some portion of them, I just know from my personal experience, will resolve for a private reproval or maybe even a dismissal. So I think that the issue needs to be brought to the full committee regarding whether or not there should be a way of handling C cases, which is different, more efficient, and frankly, more fair to respondents than the system that we're using. And then the last thing that I feel strongly about, and I do think has to be revisited by the full committee, is the point that was made by Judge Wang at our last committee meeting. There is a disconnect between the way the B&P code section is being analyzed or interpreted by the state bar and the way that it's being interpreted by others, including Judge Wang and the defense bar, which is the statute does require that the record of conviction be transmitted within 30 days, but it does not dictate that the state bar court or the review department does not have the ability to take advantage of an interim hearing process before the matter gets filed as a public disciplinary proceeding. And Judge Wang's point, which I think is correct, is that nothing in the statute requires that the matter be transmitted for public hearing, which is the event that triggers the public disclosure. And a rule of procedure modification in what probably will be maybe 5.343, which would permit the review department some flexibility to have an interim determination through some procedure in the trial department before the matter gets converted to a public disciplinary proceeding, is available without having to go to the legislature and seek a statutory change. I think that issue has to be brought to the full committee. Thank you.
Okay, I followed up with Judge Wang on her her interpretation of that, and Erica Doherty, an attorney in State Bar Court, and we kind of hashed out that issue. It would require a rule change, and there is debate whether or not it would require a statute change too, because of how they've been treating that transmittal. And I'm not an expert in this, but we can bring that. We have thoroughly looked at that issue as a way to handle this before it becomes public, but it would at the minimum require a rule change and possibly still require a statute change is the result of the discussion I had with them, which is why it might be cleaner to allow more time, just to ask for that statute change to allow more time, so OCTC has more time to gather information on the charges before it does the transmittal, which is what I think the statistics provided us. We got a lot of Corey cases and they were older, and so we needed a lot of follow-up that OCTC only has those 30 days to transmit it. But I will turn it over. George, you have your hand raised.
Yeah, I just wanted to say that with respect to Corey cases, while the statistical analysis is what it is, I just want to point out that may be skewed somewhat by the fact that this is picking up that bulge of older cases that came in starting in 2019, because my understanding is we hadn't been receiving Corey information for a while. And so there was a bulge that came in then that constitutes a population of cases that is older than we would expect going forward. And as we saw, age is one of the correlating factors that correlates with dismissal. So I think that just needs to be taken into account in interpreting these statistics with respect to Corey cases, because it is kind of a time period that covers that unusual event that occurred in 2019 when everybody got re-fingerprinted. And my understanding is we picked up a bunch of way older convictions that probably should have come in sooner had we been getting Corey information on a regular ongoing basis, which we are now.
Okay, thanks, George. And Ellen?
I just want to ask if you would also include either Ed or myself when revisiting the issue that you discussed with Judge Wang and Ms. Dougherty. I would appreciate it if we could be included in that.
Sure, I was just following up, and that will be presented to the full commission. We will bring that interpretation.
I'm just saying, if you're going to prepare a presentation to the full committee, I think it would be helpful if a representative of the respondents bar was a participant in the presentation before it gets to the full committee.
Okay.
Thank you.
Well, Justin, I would think that members of each subcommittee would have some participation, correct? Because, for example, in the ENEC committee, there was somebody from OCTC, myself, as well as respondents, bar, et cetera.
Right, and I was just, my following up with Judge Wang was, she mentioned something in a meeting, and I just wanted to follow up to clarify with that. So I wasn't trying to hold any meetings or anything without that. It was just a further clarification of the principle that she was trying to propose and whether or not it was workable, and that's why. But yes, the intent is to provide input from all sides.
I'm a little confused about the next steps. I did not think we were having another meeting with Judge Wang and anyone to talk about that particular proposal. Is that?
And I wasn't, it was when these, so I was trying to globally ask for recommendations coming from this working group. I wasn't intending to have another meeting with Judge Wang on that specific issue. But when moral turpitude was to come up to the full commission. I was asking for like specific recommendations that could come from this working group. And as part of that clarification, one of the recommendations was something that upon further follow-up, I don't know that it can be just simply enacted through a rule change.
Okay, and it sounds like there's 3 members of this working group. Melanie has no recommendations. Ellen has several. And I don't know if you have a recommendation, Sean. Is that what I'm?
Not right now, no.
So could we have Ellen write up her recommendations? And is that an approach to take?
Well, I can write up a summary. I'm not sure they're all recommendations, Leah, but I can write up a summary of my points, and then the one recommendation would be that the full committee consider the issue regarding a pre-public filing methodology for the possible resolution of conviction matters.
And Ellen, because that's kind of the concept of the ENEC, to have an ENEC in criminal conviction cases, because it's before it becomes public, and it provides that judge's overview. Is there a different mechanism that you would like to go about that, or is that similar to the ENEC?
Well, there is an overlap, because part of the issue that we're debating here is the language that requires there to be a transmittal if it's a crime involving moral turpitude, or it may involve moral turpitude. We've been over this now several times. OCTC does not and has never referred every single misdemeanor. Okay, the felonies are in a different category, and the moral turpitude per se crimes are in a different category. So those are not really the concern. So keying in on those misdemeanors, which are may or may not offenses, the issue is to permit OCTC and the respondent an opportunity to be heard, so that a determination could be made that the crime is not a may or may not moral turpitude offense. And once that determination is made, there will be no public filing and no public hearing. And obviously there is a category, and based on what we just saw, it looks like there are a significant percentage of cases where that's the ultimate determination. So there is a crossover between either using an ENEC or some other process. Maybe it's not an ENEC, maybe it's a modified or preliminary probable cause hearing of some sort. But they're not identical, the issues.
Okay, Sean.
Yeah, so Ellen, thanks for that. So Justin, I just want to be sure I understand. So we have a working group on ENECs, and if I'm understanding what you're saying correctly, they are intending to propose to the commission achieving the goal of having ENECs in C cases of the type that Ellen just described that could possibly result in non-public resolution.
Well, there wasn't unanimity out of the ENEC working group, but one of the proposals was to extend the time from 30 days to 60 days to allow for an ENEC in criminal conviction cases.
I see. And I think based on our discussion, Justin, offline, the staff has determined that ENECs are available now in C cases, right? There's a timing issue about whether it's realistic to do it private, but there's nothing that says you can't have an ENEC in C cases. Is that right?
So if I could answer that, Sean, I mean, I don't think there's a mechanism right now for having an actual ENEC. There's certainly an opportunity in some cases maybe to have a discussion prior to a transmittal if somebody knew that that was coming, but there really isn't a mechanism for an ENEC now. And I know, sort of to Justin's point, I know that I'm on the ENEC working group as well. And I know that there are some people who are interested in making a recommendation to somehow incorporate an ENEC in the process. I wouldn't be included in that recommendation, but I think some of the challenges, the practical challenges that we'll all have to deal with, regardless of the statute or the rules, is that, whether it's 30 days or 60 days or what have you prior to transmittal, is we often, and I think that's why you're seeing the numbers that you see in these older cases, we often don't have enough information to make those determinations at the time of transmittal. You may recall that we recently sought a rule change to allow us to have a deposition in criminal conviction matters. And that's one of the reasons, because sometimes the respondent is the best source of information. And that often comes later in the process. So I think there are a number of challenges around building in an ENEC process prior to transmittal.
Okay, let me think on that. I see George has his hands up. Hand, singular.
And I just wanted to point out that too, the statistics on that too may be somewhat skewed by the time period that we're looking at, because one of the reasons that we may not have enough information is because the convictions are so old that we can't get the records that we would normally try to get in criminal convictions, because they just no longer exist for some of the Corey cases that came in an extraordinarily long time after the conviction. And the other thing is that right now we're required to refer when we have the certified record of conviction, even before that becomes final. So there are two things that weigh in there, I think.
Okay, so this hadn't gelled in my head today earlier, but so I think we really have kind of two issues on the table. The first is that the ENEC working group, as Justin described it, is looking at whether to seek a statutory change to extend the time to report. Ellen has, which would facilitate a possible ENEC process, although even 60 days may not be long enough because of what Melanie described, or George, or both of you. And so then there's the other issue of whether these transmittals should be immediately public, or they should remain confidential for some period of time for those cases that could possibly result in a private reproval. So it seems like those are two different issues. They're both ways that could make a procedure for having an ENEC and a possible private resolution being feasible. So I think maybe what we should do, I think Leah is on the right path, Ellen, is maybe that you should write out these proposals and then present them to the commission. And then we can kind of, because it's gonna dovetail with the ENEC committee. So you might perhaps with Justin and Lisa, you could do a supplement to the ENEC working group's report of your views on this and alternatives. And then we can tee up something to the commission that's pretty refined. In other words, here are certain specific proposals the commission can vote on. So we discuss them and then vote up, yay or nay on each one.
Yeah, with your permission, I'll include Ed Lear. I mean, he's on the ENEC working group. I know that he's in arbitration this week, all week, because I'm an expert witness in that case. But I will get with Ed and I will prevail upon him. And by next week, either I or he and I together will put something together.
Okay.
Okay. George. You're on mute.
All I would ask is that we get that so that we can review it and determine kind of what position we might take, so that we can also provide that, so that the commission basically has, I think, both sides and can see where there's agreement or disagreement.
Okay.
That sounds good. Yeah, because the more that we can refine and distill the issues for the commission, I think that it'll be a much more productive and efficient conversation, because the commission's going to have a lot of different things to consider. So I think this is a good game plan. And then Ellen, did you have other proposals you wanted to tee up at kind of a high level to go to the commission?
Well, again, I just got this report late Friday evening, but I do want to look more carefully at this most recent report. To me, the number of dismissals or, non-disciplinary dispositions is significant. And I think that's something that needs to be further explored. I don't want to take a lot of time now. We all, it's been, a fulsome meeting, but there is a continuing issue regarding the extent to which lawyers should be disciplined for what you might call lower level misdemeanors that have no nexus to the practice of law, that don't involve a client, that don't involve deceit. And so that's an important issue. And I do anticipate proposing something that relates to that.
Okay,
Okay, so I think we can probably use the same process we've outlined, that you can work with Justin to prepare something that can be submitted to the commission and discussed at the next meeting.
okay,
Sounds good.
All right.
all right. Does anybody have anything else? Okay, well then I thank everybody and we will adjourn.
Thank you.
All right. Thanks, everyone.
Thank you.